I will also ask up on stage Alexander Humph, who is the co-founder and the CEO of Think Privacy. He will start by a little introduction session in regards to the topic of this panel, which is enforcement and sanctions. We will also have on stage with us, and I should say Alexander is a very well-known person in regards to privacy in the digital age. Amongst the other things, he has been the expert advisor both to the European Commission and the European Parliament. So that will be an interesting introduction. We will also have on stage Oltan O'Carroll, who is the Assistant Commissioner for the Irish Data Protection Commissioner. And Oltan works in supervisory and awareness role relating to technology usage. Last but not least, we have Albin van Vincent, who is the head of the DPO's department at CNIL. And her team is providing proactive assistance to DPOs. And from what I can read, it's really innovative and a smart way of doing it. But let's start with your introduction, Alexander, and then we will go into the panel discussion.
Okay, so first of all, you don't need to photograph these slides. My colleague Frederick will do a full presentation on stage 2 this afternoon. This is really just to lay the foundations of the discussion for the following panel. When we look at, so we did some research earlier this year on sanctions that had happened. We reached out to all the supervisory authorities across all member states, including Norway, etc. And we found around a 60% return rate. So about 40% of supervisory authorities didn't respond to our inquiries, which creates a big problem because enforcement notices are not just about the penalties that come with those enforcement notices. They're a learning tool as well. They give us an illustration of how the law is being applied and how it's being interpreted. So if we don't have transparency about these enforcement notices, it makes it very difficult for organizations to understand what their obligations are in areas of confusion. So as you can see, we've had around a 60% return on those. Despite what people think, there have been quite a significant number of enforcements, over 240 enforcements so far in the last year. And we're starting to see some patterns emerge. One of the biggest patterns we're seeing emerge is that principals are playing a large part in enforcement. So organizations who don't meet the foundational principles of GDPR are facing issues. And as you can see from this slide, a large number of enforcements have had principals involved with them. Consent as well has proven to be a problem, and transparency and InfoSec. So we're seeing some of the areas that are common across enforcements across different member states, being principles, consent, transparency, and InfoSec. And with regards to the violation of principles, we're seeing issues with integrity and confidentiality, accountability, but we're seeing more a general application of principles or a general lack of application of principles in the cases where there have been breaches. So we're not just looking at specific principles. It seems that when we look at the market as a whole, there seems to be not very much focus on principles at all when we're talking about how data is being processed, and more focus on things like legal bases. Administrative fines. We haven't included the Google fine in here because it distorts the figures, but we've seen administrative fines of around 11 million euros so far. This doesn't include the notice of intent against companies like BA and the Marriott, a Marriott hotel chain. This is purely enforcements which have occurred. And areas where we're seeing a lack of enforcement or enforcement gaps, as you can see, things like the right to restriction, child consent, automated decision-making, although there will be some of those shortly, I suspect, DPIAs, etc. So we're seeing patterns emerge already. We're seeing certain areas which haven't reached maturity from an enforcement perspective yet, and other areas which are coming up all of the time. So really, that's the foundation of the discussion we're going to have now, and I just wanted you all to be aware. And as I said, the full presentation with all the numbers and figures will be this afternoon on stage 2.
That was very efficient, thank you. So I think the first question will be to our panelists representing the DPAs. Any reflections on what Alexander just showed here? Lena?
Well, I think it's given a picture, and then I think we recognize the picture. And I think one surprising thing, if we have reflected on this a year ago, I wouldn't have thought that the basic principles and the Article 5 and 6 would be that big of results from the DPAs. But I think also that we have to start somewhere, and everybody's starting at the same point. So I think it will take some time before we have the broadened picture.
I share the picture you've done, and your last slide is very interesting regarding the gaps we have to look at, especially the child consent, because as you know. We elaborate each year a program of investigation, and this point has been at the annual program for the French DPA. So I hope next year that will be different. But we are just at the beginning of the GDPR implementation, so it's very interesting to have an external point of view, because sometimes, you know, the figures and numbers are so different. And I think also at the European level, that would be interesting to share this information. Thank you.
I'm not sure. Did we respond to your survey?
No.
Well, I think
Neither.
even if we had responded to your survey, we would have said that these matters are confidential in law. So in Irish law, case matters are confidential and can't be discussed. So we're not even FOIable, for instance, beyond our administrative work. But one of the things that we've done that has happened in the past is to do with publication of reports on audits and investigations that we've done, and we couldn't do that before. Under GDPR, it seems that we can, and we will be doing that. And that's a great tool of enforcement now that we have, which will, I think, have a huge effect on the way organizations approach us and approach compliance. So I look forward to seeing that in future. One of the other things, as Ameline said, on children, we've done a code of conduct, we've done a consultation with the public and with children on what they consider should happen with consent under Article 8 for minors. And we've had a large response both from public and from schools. We've done lesson plans with schools on kids' consent. And organizations have come back to us during the public consultation period and said, yes, we're very interested and we want to be responsible in this area. And they are open to codes of conduct, as we've mentioned in the previous session. So I think that's something that's going to grow on our side, and we'll see a lot more work from our commission on that as well.
And we do, of course, have the YouTube child consent case currently undergoing. So this is from earlier on in the year. We still don't have a specific judgment on child consent, but there is movement in that area, I should clarify.
No, and we had a really interesting conversation when we had the preparatory call in regards to where are we now with GDPR. Is it so that, well, I think we most of us can agree that the big buzz around GDPR came from the risk of the high sanctions. That was how the board members understood that this is going to be something we need to put a lot of money into investing in the companies. Media were really on top of it. But now it seems like the questions to the data protection authorities are going down. Media is, if something happens, they are on it, but it's not the general buzz and so on. How do you see, because Lena, you said there's numerous of cases, a lot of audits happening at this point of time. We spoke about yesterday that it's loads of things happening in CNIO, and of course everyone knows that the Irish Data Protection Authority is under a lot of pressure to do a lot of things. What do you think will be the things that will now happen in the coming months or year that will get back the focus on GDPR? And maybe you don't agree with me. Maybe you think that there is still a major focus on GDPR among society. Anyone feels?
Well, from our perspective, I think, as you said, there is a lot of pressure on us. We have a lot of multinationals in Ireland. We're not the only jurisdiction in Europe that has multinational organizations. There are many of them. But we have got, we have talked about this in public, I think we have 61 open inquiries at the moment, 21 of which are in multinational tech. And what you're going to see, I think, in the next coming months is that the first set of those that have passed through the inquiry phase, and there are some very strict phases in the way we have to deal with these things, will move into the adjudication phase with the Commissioner. And we expect then that we'll see some of those cases going before the EDPB for the consistency mechanism. And that should happen, I think, by the end of the year. So those two, they'll also be the first cross-border cases that have gone through that consistency mechanism as well, rather than being national cases. So that's going to make a big difference, I think, in the way that organizations view and understand how DPAs deal with enforcement and sanctions and compliance. Anecdotally, of course, we hear that people are dialing back, or organizations are dialing back on their the number of lawyers they employ, their compliance officers, and so on. But two things I can see. In Dublin, at least, for instance, the compliance employment market is very buoyant. There's some very high salaries being commanded. There are a lot of positions that are open. And secondly, when we go and talk to organizations, we're confronted with more and more legal staff as well. So that's quite a change. And I think organizations are very clear on what their compliance needs are, and they do know that when they talk to us, it's a serious business.
I think also for us DPAs, I don't think the bus is totally gone, but I agree with you, Michaela, that it's when something happens, and now it will happen that the DPAs come out with decisions and sanctions and fines, and they will be followed closely, I'm sure. But I think also it's a very important question for us in the DPAs. Starting at the same point, we have to take responsibility to have a wide spread of questions and organizations and sectors that we investigate and do audits in. Because I'm not really sure if it's true, like you say now, that everybody is turning their head down and waiting. Maybe slow down the investments in privacy protection, because we don't know if this is really happening for real. And I think it's also important not only to go on the big ones. Of course, they are processing a lot of personal data, but it's not sure that fines to Google has a big meaning for me in the transportation sector, or if I'm in the hotel business. We need to have a spread to make this really becoming something for me in every branch and section in society, I think. So I think we have a responsibility also to make a wide spread within the EU.
And Alexander, you look on this on a helicopter view.
Yeah,
Like, do you agree with me? And then Lena seemed to agree with as well.
And I've reached out to various other industry groups as well in recent weeks. And so, for example, I had a conversation with the IAPP just last week. They've noticed a very significant contraction in European business over the past 9 months. We've noticed at the ground level as consultants and advisors a very significant contraction in business. Just a week ago, I had a member of a C-suite from a major financial institution come to me and ask if there's anything we can do to increase or to revisit awareness raising within the organization. Because he felt at the board level that the buying within the organization was waning, that there was a significant lapse in attention to data ethics, data privacy, and data protection. And what can we do to remotivate their personnel to take these things more seriously. So at the ground level, there's definitely a downturn in the market. That's without question. Whether or not that will change with more enforcement, I understand the resource issues that supervisory authorities face. I understand the time lag it takes from the implementation of the regulation in May last year through these very technical and very long and legal investigations. But at the same time, if organizations feel that they can just rest back on their laurels because there's a very limited risk to them, then it makes it very difficult to move the discussion forward.
Yeah, I agree. During dinner last night, we had a really interesting discussion in regards to the fact that enforcement and sanctions levels and the procedures, they vary a lot across Europe. And the discussion we had was about forum shopping, and I'm looking at you now a bit because we had some different views. Is it so that there is already forum shopping out there, that there are ideas from organization to now move their headquarters to Romania or other countries that have lower fines or whatever it might be, or at least having the strategic decisions being made there? And also, are there things that the data protection authorities and the EDPB can do in this regard? So, yeah, maybe we can continue what we spoke about yesterday.
Yeah, we were disagreed. In my point of view, the forum shopping concerns cross-border processing. So the situation is not the same if it's national processing, I don't know, a school, an hospital, a very local bank or something like that. It's not possible sometimes to avoid your responsibility with the forum shopping. But also, we are bound with the regulation. We are not alone to decide. We are all together, and the European board is there to check and to verify also our compliance to the regulation. So maybe there is some case of forum shopping, but I cannot see them. Maybe we can have a long discussion on this. But if there is cross-border processing, it's very, very limited, in my point of view.
Okay. Alexander, you had something to say on this last night as well?
Yeah, so it's very interesting. Just under 2 weeks ago, we had the German framework for enforcement of administrative fines was published. I know that there are 3 or 4 different frameworks being considered by EDPB currently on how we can apply this consistency mechanism across all member states. With regards to, which is a welcome thing, obviously, and the formula behind the German framework is very methodical and very mathematical, and seems to be widely accepted as a good example to move forward with. We have had some examples of issues with cross-border processing. So, for example, Ireland recently had to hand a case over to Belgium because a controller refused to even reply to communications from the Irish DPC. So in situations like that, where there's clearly a cross-border processing issue, if controllers are refusing to communicate or to answer communications from other supervisory authorities which aren't their lead supervisory authority, that creates a problem in and of itself. And in this case, it was the Belgians, so we assume that the Belgians will take this matter very seriously. But there could be other jurisdictions where there is less of an appetite for enforcement, where this could become a problem.
Lena, you said that it's important that we also spread the actions towards not only the big players and towards different types of sectors. And I'm wondering if there should be anything that can be done within the EDPB in regards to that, if it is so that guidance or rather, how should I put it, that organizations across Europe, they're not only looking to their own country for guidance in regards to precedents and so on, but across Europe.
Well, I think it's really important to have one-stop shop even for information what happens in the European countries. And I think your presentation, we are really eager to have those kind of summarizing conclusions of where are we in the European states. And I think we have to take the responsibility to have this kind of helicopter view to get the most impact on privacy on a European level. And that's our aims. And I think also it's very important for us as a DPAs to collect what's happening in other countries, because we have to analyze the decisions, because they're our decisions in a way. We have the same legal framework. We have to interpret it in the same way. So we have to take it in. What happens in other countries are just as important to us as our own decisions. And we have to get a smooth way of getting transparency in this kind of respect. And I think only to get back to the point of forum shopping,
yes,
I don't know if that's something that's really going to happen, or it is, if it is happening right now. But I think we will have a problem, because all the national legislation, we have very different administrative laws that even if we have the GDPR to be interpreted in the same way, the administrative handling of cases will differ a lot. And that would, in the end, make a risk of forum shopping, I guess.
Another thing that has been spoken a lot about is, and also Lena, you brought it up in your keynote speech, it's about how to use your resources in the most efficient way. And I know, at least outside of Ireland, but maybe within your commission as well, there's been a lot of discussion, is it sufficient number of staff? We had a discussion about that yesterday. And the question, two questions here is in regards to how should data protection authorities use their resources in the best way? Guidance, sanctions, workshops, whatever it is. And secondly, is it so that overall there is a need for more resources?
I think I'd love to have a data protection authority that had man marking, where we had one staff member for every member of the public. But that's never going to happen, of course. We have to rely on deterrence to some extent, and we do rely on, at least in our case, on government giving us the funding to acquire staff. So when I joined the authority back in 2013, I think we had 28 staff and a budget of about just over 1 million. We're now up to 15 million, 137 staff, and we're hoping for more in the next budget that is due to come very shortly. Our approach to compliance is to take both the supervisory approach to engage with organizations, because we think that will lead to better outcome eventually. It also means that in some cases we can go and achieve a result without going through the courts, which can be very expensive, time-consuming, and resource-hungry. But we also, of course, go through the enforcement approach on the inquiry side. So the consistency mechanism and the forum shopping question, I think, for those cases where there are cross-border processing operations involved, we're going to rely on that mechanism to help us get through those, because the mutual assistance ability and the joint operations ability allow us to exchange expertise and resources on these things, and we're already doing that, and we do it a lot. The IMI tool, as Amy will know, is very, very hot in Europe. There's a lot of traffic on it, a lot of discussion goes on, a lot of exchange of information. So we're going to see that, and of course, if we can get more staff, then that'll be great too.
There is always a need for more money to make great things happen. But I think we have to live with the fact that we can't get any more money. We can have a small amount of money for a few more staff members, but I think we have to face the fact that this is what we have and we have to make the most of it. And I think in that respect, as I said, I think it's really important to figure out what tools should we choose and use in what situations, because having compliance with the GDPR in small businesses, maybe not audits are the best tool, but information and making them understand and making the board take the responsibility to start the travel in that small business. And then information, education and know-how, awareness raising, I think that's important too. So we have to try to very much using very small resources to make big effects. And audits are, like you said, also very time consuming. And we can expect that all our decisions will be appealed. So we will have a very long time before we really know what is the final decision of our decisions. In France, we have what we call the two legs of the regulation. There is one leg for enforcement sanction and another leg for the support of the professional, and also hands and other tools for education and this. It's sometimes you have to use this tool and another tool to maximize the effect. But first of all, without helping professionals to better understand what they have to do, that's impossible to be respected. There is the law, there is a legal framework, national framework, but
to be able to share the activity, to understand all the business, all the real life of this professional who can be from public body or economic sectors. We have to be close to them. So that's a very part important of our activities. We are more than 50 only for that. And the department of the DPOs where I am working on try to do the best for that. There is a phone line, email line to get expert and answer the many questions they have, but also online tools to help them, and especially massive online course, some MOOC, to give information on what is data protection, because all of us in this room, we know that, but many professionals don't know about it. So it's very important to be sure that we are talking about the same topic.
Yeah, yeah.
The resources question is very important. 2010, I wrote the criminal complaint against Google Street View in the UK. And I remember having a conversation with the ICO at the time and was told that they would not be filing charges against Google because they couldn't afford to defend the appeal. The law has changed since then, but the lack of resources hasn't.
No.
And if we go back to the forum shopping discussion, forum shopping can happen as a result of lack of resources as well. If you know that a specific supervisory authority does not have the resources to do their job, then it's a favorable place to establish your organization, because the chances of enforcement are going to be significantly reduced. So we do need to address this issue. There's also a question of independence.
Yep.
How can a regulator, which is required by law, be independent if they have no control over their budgets, their allocation of funds and resources? So there are a number of issues that we face which make it very difficult to have independence and to avoid forum shopping and to ensure that there's effective enforcement if the resources there aren't appropriate. So I, for one, hope that you all get more money. I think it would be really, really a good thing for the privacy ecosystem if we did.
No, and it comes back to the previous discussion we had before the break about clarity and controllership and processor. In the end of the day, most of these cases will be appealed all the way to the European Court of Justice to get clarity, and that is going to be a lot of resources on both sides. So obviously, if we as companies should get the clarity at the end of the day that we need, then we need to also have these cases go all the way.
Exactly, and we know, of course, in a court of law, if you're going to go up against Facebook with 15 QCs arguing their case, you need to have an appropriate level of legal resources to combat that. The cost of that is astronomical and certainly goes beyond the budgets of most supervisory authorities.
I think it's a bit of a leap, though, to say that just because you have a small number of staff at a DPA that leads to less enforcement. That's not the case. The law has a long arm, as you know, and can take time. It can take time to get a case up and running and going, but because we have to follow all the procedures and get things right, and there are technicalities all along the way, it might take time. But organizations shouldn't believe that having a small number of resources at a DPA means they're going to get an easy job, and especially if they're in a cross-border processing situation, because the consistency mechanism, the EDPB, are part of this, and they weren't before. So I don't take what you say fully. I understand where you're coming from, but forum shopping may have been a longer or a more existent problem before with the EDPB and the GDPR and a single regulation across Europe. I don't think it's as evident as it's going to be, as you might think.
Okay, yeah. Any questions to the panel from the audience on this topic? I would assume this is an interesting one. Yep, there's a question over there. There's an orange mic there.
Sorry. Yeah, it works. Hi, I'm Shura. I'm from the Netherlands. I'm an external DPO for 5 companies. And I have a question for the 3 DPAs, because as Albin Vincent put it so eloquently, the GDPR has 2 legs, the DPOs and the enforcement. But the two legs are connected to one body. And this is my key question for the three DPAs. How do you separate the information that you're maybe given confidentially from a DPO that has a really difficult dilemma and wants to get some guidance, but does not want to be subjected to enforcement as a consequence of asking for help? Thanks.
Good question.
I'll try that first of all. Supervision involves engagement. Enforcement involves engagement as well. In both cases, you have to talk to organizations. We always tell organizations when they come to us to tell us about their latest product or what they're planning to do, that anything they say to us can and may be used against them in future. And if we do that, we'll tell them we're going to do it. You know, if we hear information, we can use it. It's intelligence. We can use it, and if we need to, we will. We're clear.
So how does it help?
It depends on the situation, but usually, no. I don't know one case where a company comes to see us and explain the project, and after there is an investigation. I have never seen that at the CNIL, but the situation were very clear. And it was a discussion about the case, about the project, and we consider that this is a confidential place, and we don't talk to our colleagues of the enforcement department. That's all. And for the moment, it works very well, because we have many demand of appointment and many things.
Well, I agree with you. It's the same in Sweden, that we have to support the data protection officers. It's a prolonged arm out in society, and we have to be able to have some kind of communication. And all the discussions concern problems and challenges that the DPOs meet in the daily business. So we have decided that we need to have a channel to make discussions, and we need to have a high standard of discussions and the high ceiling to discuss. But if we have an ongoing audit, that would be something that we'd say that we would not discuss this case, of course. But we have to have a communication line with the DPOs to help them in their preparations, of course, without always taking notes of what's problematic and then start an audit on that one. We have enough signals to do audits anyway, so we have to prioritize.
For sure.
Yeah.
I have time for one really short question, if there's anyone that has something pressing. No? Crystal clear when it comes to sanctions and enforcement. That's good to see. Well, then I propose that we thank the panel for this very interesting discussion.
Thank you.
Thank you.